Good evening, this is John Milburn. This is Laws 11057, Introduction to Law. It's week 11, term 3, 2015-2016. So down to the business end now. Those of you who have already submitted your work for the third assessment piece, thank you very much. It's due tomorrow, that is the 4th of February at 11:45 p.m. All of my assessment work is due on a Thursday evening at 11:45 p.m. It is subject to a final cut-off the Saturday week. So that's 9 days after the assessment. I won't accept any further work. At that stage, if you don't have work submitted, it's a 0 mark. And the reason I do that is so that I can ensure feedback to students as quickly as possible. And the feedback in this instance, I hope, will be with you on the Sunday week. So I'll mark progressively during next week. If there are any questions on that, please let me know. If anyone has any feedback in relation to the assessment without being too specific, please let me know, and I'd be interested for your thoughts about that after I've finished the assessment marking or even after you've submitted your work. And the reason is that this is the first time I've offered that type of assessment in assessment number 3 in Introduction to Law. One of the courses I take is Alternative Dispute Resolution, and one of the skills that I call upon is the ability to interact in an online forum using audio-visual techniques, for example, for a mock mediation. And it occurred to me that it would be useful for students in Introduction to Law to get used to that technology, because I know I'm not the only one. As I understand, Anthony Marinac uses audio-visual presentations in contract law. I think Stephen Colburn does as well, Professor Colburn, in civil procedure. So for those of you that have mastered the technique and uploaded your assessment ready for marking, thank you very much. Now I understand, and please correct me if I'm wrong on this, that the way to upload your assessment is to mark it as public. That means I can view the material. I'm not sure there's any other way we can do that. If anyone does come up with any ideas, please let us know, either tonight or perhaps through UCrew. There's been a bit of a discussion about that, and I've suggested that it has to be public. If you're concerned about uploading it so that everyone can look at this video, then please let me know. Give me a window of opportunity. I'll mark it, then you can delete it off UCrew. Sorry, off YouTube. Okay, so if there's any questions about the third assessment, let me know. Now onto the exam, I'm going to repeat. So Emma said, I marked mine as unlisted and emailed someone else who followed. Did you want to tell us about that, Emma? Or I'll just see if I can keep up with the conversation. Emailed somebody else who followed the link and could view it, so I hope that works. All right, so unlisted seems to work. Jazz said, I think you can upload the assessment so that the only person with the link can view it. All right, well, thank you for sharing those thoughts. Please add your thoughts onto UCrew, where there's the discussion has started on that point. And I want to ensure that there's minimal impact on you in terms of providing your assessment work, but still, of course, allow me the opportunity to read the material. Read the material and also, importantly, view the audio-visual. And part of the assessment is your communication skills. I appreciate it's to camera, but it's still an important function, and it helps with your advocacy skills as well. All right, so thank you for those thoughts. Now onto the exam. I'm going to cover some material that I covered previously, I think probably in about week 7 or 8. I will provide some notes on the website and also UCrew. As you know, the exam is 6 of 7 questions, equal value, 10 marks each. Pretty straightforward. All are essay-style questions bar one exception, and that is the redrafting exercise. We'll be doing some redrafting later in tonight's session. The exam is open book. You can write your answers now if you like, and simply rewrite them in the examination. I'm sorry it's a writing exercise in the exam. We really do need to get away from that type of process, and progressively, I'm sure that will happen. But for the moment, it's a written exam. You know there'll be separation of powers, you know there'll be drafting of legal gobbledygook, if I can use that term. There'll be a whole range of other things that the exam questions may relate to. Judicial activism, the process of taking instructions, from a client preparing proceedings, you know, basic civil, basic criminal law matters, basic contract, appearing as an advocate, again, basic civil, basic criminal matters, getting called to the police station, I use that one quite a bit. Almost certainly there'd be something to do with self-management skills, your ability to maintain proper equilibrium. You know that's something I'm very strong on. So I want to see what you've done. What is your version of keys in the fridge, etc. For those of you who have heard me before, you might understand what that reference is all about. If not, I'm sure you can work out what it means. Undertaking legal research skills to a degree, that's difficult to test in an examination, but there may be some questions about that. Being a critical legal thinker, being a good communicator. Obviously, we're primarily testing your written communication skills. We do that in the redrafting exercise, but it's an opportunity for you to tell me what you have done to ensure that your communication skills will be of the highest order once you start to practice. Issues to do with access to justice, administration of justice, ethical obligations, that will always flow through. We'll talk about ethics a bit tonight. Effective legal writing, ethical duties of lawyers, resilience, common law versus equity. These are a whole range of different things. So what's in the exam shouldn't come as a surprise. I've been through that list a couple of times. I'll put some commentary on the website and UCrew. I'll add some extra commentary as well. And if there's any questions, please feel free to ask now, or perhaps through UCrew if you wish. Obviously, electronic devices are not allowed. Anything that would allow you to access the internet is not allowed. So don't take your phone into the exam room. Then you have to leave it at the side. Rather, just leave it in the car or leave it at home or whatever. Don't take in a standard dictionary for some reason. That's not allowed. All right. I don't think there's anything else that I need to say about what you can take into the exam and what you should not take into the exam. If anyone disagrees with anything I've said from their reading, please let me know. But so you can take in your textbook, you can take in your own notes, you can take in reference material, legislation, whatever you like. But obviously you need to be well prepared, and you understand, of course, that because it's an open book exam, I expect a higher standard. Also, of course, and I think I've mentioned this before, don't be too concerned about footnote referencing. I know that's really difficult when you're handwriting. So just use Harvard-style referencing. So if you make a reference to a case, then just put in brackets, or a commentary, say a quote out of The New Lawyer, just put in brackets The New Lawyer, page such and such. Don't be too concerned about formal referencing. If you want to, that's really good. But my main concern is to ensure that you have identified the source of your material. So you can use a shorthand version of that in the handwritten exam. So The New Lawyer, page 27, that's fine by me. If you want to go further and say the name of the authors and then the publishers of the book, you can, but I really don't want you to waste your time on those sorts of niceties in this context. I hope that makes sense. The exam, it's in writing, it's in essay style. So you do need to ensure a use of formal language. I think those of you have followed my work to some degree through the sample document and what I've said, you will understand that I don't like the abbreviated form, which is ironic because I've just said don't in the context of explaining that that's not what I want. So in the written form, write should not instead of shouldn't, or will not instead of won't, for example. I hope you know what you mean. No text message shorthand. So not the letter U instead of YOU, for example. So it's still got to be of a professional, somewhat formal standard, but I'm sure you all know that when I talk about a formal standard, that is poles apart from pomposity. So no pompous language, please. Maybe if one or two, if you want to. One of my mentors in legal writing is the newly retired Justice Alan Wilson of the Supreme Court. And I had the pleasure of undertaking an effective writing course with Justice Wilson, and that's part of my judgment writing in QCAT. And Justice Wilson is a wonderful communicator in written form. If you see one of his judgments, I'd commend it to you. It's very much along the lines of sort of a Lord Denning style. Generally short sentences, easily communicated, flows nicely. But Justice Wilson is very articulate and very knowledgeable in the English language. So he did confess that from time to time, just more for his own, not amusement is the right term, but just so that he feels he's adding something a little bit more technical, he'll throw in a few words that require access to the dictionary. But there's nothing like reading like a Stephen Fry novel where you're constantly having to resort to the dictionary. Although, having said that, I do enjoy reading reading Stephen Fry's work. So nice and simple, but still keep it formal. In terms of the assessment, remember, of course, the format. If you're stuck, if you're wondering how to go about answering this question, go back to basics, IRAC, MIRAC, CIRAC, whatever of those acronyms you think is the best way. But just follow that general formula is always a good way to go back. So use complete sentences. Again, that is more in terms of a little degree of formality. You can use dot points if you like, but I'm not a fan of dot points, so be selective if you would. Also, in short sentences, I keep saying this, but it is important. Try, if you can, to use the active voice rather than the passive voice. I think we've covered that a fair bit. And generally, if you're using an active voice, you'll convey more information. So the development proposal was rejected. Well, that's passive voice. The council rejected the development proposal. That's active voice. So the first one was passive. So the council rejected the development proposal. That's the active voice, and it tells us more information. It tells us it was the council that rejected the application rather than the passive. The application was rejected. So keep that in mind as well. Make effective use of your time in the exam. I mean, as a general rule, it's pretty simple. Arithmetic, you've got 6 questions. You've got, I think, 180 hours. So what's that, 30, I won't attempt to do the maths, I'm too tired. But just work that out. So what is that? 180 divided by 6. Can someone help me? 30 minutes? Is that right? Gee, that seems an awful long time. That's a long exam. That's really cruel. I'm sorry. That's what I was thinking. It's 30, but that just seems so long. So keep at it. Be resourceful. Stay calm. Breathe slowly. Take a short break if you need to. Don't be overwhelmed at the start. Make some notes to yourself. And make sure that you at least write something. Remember, of course, that the first 50% of the marks is far easier to get than the second 50, and it becomes progressively harder from there. So the most difficult 20% will be the final 20%, but I'm sure you all understand that. All right, so back to basics. I'm just going through some notes that I've written for myself. Dot point, yeah, I think we've covered most of those. There's no word count expectation at all. And you can make some notes during that 30-minute reading. I believe you can make notes in that period of time, but I don't get involved in the exam process, as you could probably painfully tell. I do receive the exam papers, but I write the exam that's been written ages ago, and I do get the exam to mark. There will not be the sort of feedback that you're expecting, that you might expect in assignment work with the exam. You simply get a note of what your mark is for the exam. Okay. Do take a moment, if you can, to proofread. Silently read what you've written, because it's remarkable how often I read a paper that it just doesn't make sense. And it probably shows a degree of panic or a degree of lack of care, perhaps, but read it out aloud. Look, a good way to deal with things in an exam too is to state your conclusion and then argue towards it. And I do that a lot in submissions, in criminal law matters in a sentence, for example, I may submit that an appropriate penalty, respectfully, is a term of imprisonment for 18 months, or say 9 months, but subject to immediate parole, for example. So that would be where you state your conclusion and then you argue towards that to justify that conclusion. Okay, so if there are no other questions, I'll move on to the next topic. I said I wanted to speak a little about professional ethics. So, of course, make sure that you have read the Australian Solicitors Conduct Rules 2012. You must have those handy. Bear in mind that you've got duties as a lawyer to the court, that's number one, and to the client, but you've also got duties to colleagues, and don't forget the importance of your family and your employer. You know, really, it's, I'm not sure it's appropriate that people might spend 30 hours preparing for a relatively simple matter when they should be thinking about what's in the best interest of their employers as well. All right. Now, in terms of the Solicitors Conduct Rules, there's the fundamental rules in 3, 4, 5 and 6. Rule 3 provides, very importantly, that the solicitor's duty to the court in the administration of justice is paramount and prevails to the extent of any inconsistency with other laws or other duties. Rule 4, have a look at that. The ethical duties must act in the best interest of the client, represent the client in an honest and courteous way, and the issue of relations with clients is dealt with in Rules 7 through 16. Have a look at 8.1, the obligation to follow lawful, proper and competent instructions. There's a lot of questions in exams about that type of thing. Is the client's instruction lawful? Is it proper? Is it competent? And as you know, in order to determine whether it's competent or not, you really need to understand the definition of capacity. Guardianship and Administration Act. Have a look at Advocacy and Litigation, Rules 17 to 29 inclusive. Now, bear in mind, I'm referring here to the Solicitors Conduct Rules, but equally, you must pay attention to the Barristers Conduct Rules, and feel free to refer to the rules as they appear in your jurisdiction. So if you're, for example, you're a student in this course in Victoria, I have no problem with you emphasising the Victorian situation. Even if the question seems to relate to Queensland, don't be concerned. My main aim is to ensure that you're learning something that's relevant to you in your practice where you might ultimately practice. For barristers, have a look at the Advocacy Rules, that's Rules 12 to 14. The rules about duty to the court, 25 to 36, duty to the client, 37 to 40, and court process and privilege, 59 to 67. So lots and lots of reading there, but it's important. And I think there might be a microphone on. Mitch, I think your microphone might be on. If you're able to turn it off, that would be good. Feel free, of course, to ask any questions or come in as we chat. All right, so I might just go to gallery view. So if you're a bit shy, you can always hide. We'd prefer you didn't, but we'll just go to gallery view for a sec. So we've got lots of people online, so that's great. And if you've got any questions, please let me know. Okay. So that's the ethical duties. Now let's have a look at the next issue, which is in relation to debt recovery. I gave you an exercise to consider the different scenarios in circumstances where we are looking at recovering a debt, for example. And this is intended to be interactive, so please feel free to unmute your microphone and make a comment live. If not, if you could use the chat facility to add some comments and I can read them for others to consider, particularly those that might be watching a recorded session of this. All right, so you're acting for a client or instructs you to initiate proceedings. Proceedings meaning litigation. So we've talked about, previously we've talked about brainstorming all the other options, but the client says, no, I've considered all those options, but I want to issue proceedings. What sort of proceedings do we issue? when pursuing a debt of $5,000. So, firstly, where would we consider going to pursue a $5,000 debt? Has anyone got any thoughts? You can localise it for your jurisdiction if you wish as well. You can unmute or come in live. So your client says, I'm owed a debt for $5,000. Where do we go?
Hi, John, it's Mitch here. Could you go to QCAT for that?
You can, yes, depending on what type of debt it is. But generally, yes, QCAT would be a realistic option. Obviously, there are issues to do with the jurisdiction. It must be a Queensland debt, but it's not something that you could do for certain sorts of debts. Or it may be, for example, in family law, if you're acting for a party who is claiming $5,000 from the spouse, then you probably wouldn't go to QCAT. You'd probably go to the Federal Circuit Court. So those sorts of issues as well. Now, could you go to the Magistrates Court for a $5,000 debt?
No, the Magistrates Court is amounts over $25,000.
No, not quite. What's the upper limit for the Magistrates Court? Does anyone know the jurisdictional limit for the Magistrates Court? $75? Question mark. All right, so have a look at that. I want you to go and research the jurisdictional limit for the Magistrates Court. It's a bit more than 75. I won't give you the answer. I'll get you to look that up. What's the jurisdictional limit for QCAT? Anyone got an idea?
25,000.
Yes and no. Given that QCAT has two types of jurisdiction, it has its small debts, minor civil disputes division, and the other one is unlimited. So Jazz has said magistrates is 150. Thank you, Jazz. That's correct. QCAT is, I think, it is 25, I think, for the minor civil disputes. Have a look at that. I mean, I just don't practice in that area, even though I'm a member. But the other is unlimited for QCAT. So when we were talking about suing for $5,000 in QCAT, bear in mind, that it has to be something within the jurisdiction to do that. And one of those examples is, say, a building dispute, a residential building dispute. A problem with a house that's been constructed. You might be acting for an owner of the property who says, look, this house is fundamentally is a real issue here. I want to sue for $300,000. You would not be able to sue in the Magistrates Court for that $300,000, but you could sue in QCAT for $300,000. You can sue in QCAT for $300,000 because it's a building dispute. It relates to a dispute relevant to a residential building contract. So there's sort of there's the money limit, but also the jurisdictional limit about what different courts and tribunals deal with. What about the district court? What's the jurisdictional limit for the district court? Anyone got that? And you could go to the district court, yes. 250, 750. All right, so
between 150 and 750.
750. So 750 seems to be the popular choice, but I'll get you to look that up. What about the Supreme Court? What's the jurisdictional limit there? Unlimited, 750 plus. So there's slightly different answers. One says unlimited, the other one says 750 plus, which begs the question, what if your client says, all right, well, it's a $5,000 debt, but I'm really, really angry with this client, this other person. I want you to take it to the Supreme Court. Can you do that? Can you go to the Supreme Court? No, says Leanne. I'm getting a lot of shaking of heads. Think about that. In your reading, have you ever come across a jurisdictional bottom limit or just a jurisdictional top limit? So think about whether you could sue for $5,000 in the Supreme Court. And if you concluded that you can, you'd think about whether that's a wise thing to do. It's not. And just think, how would the court deal with that issue? Does the court have to take on the job? Does the court say, well, you know, we take all comers, or think about whether the court has the power to remit the matter, and also think about the cost ramifications. Think about whether the court may say, well, you've just elected to come to this court, you shouldn't have, but you're not going to get your costs. We'll give you costs as if you'd gone to the magistrate's court. So your client may end up spending, you know, thousands and thousands of dollars and not be able to claim the actual amount because it was in that wrong issue. I think the Supreme Court would quickly rid itself of a claim for $5,000, but just ask yourself whether there's a bottom limit on that as well. All right, so what if your client wants to pursue a debt for $50,000? Where would you go for that? $50,000 debt.
You could probably take that to the magistrate's court.
Yeah, that would be my first thought. Chris agrees with that. Thank you, Luke. That's where I would initially be thinking. But again, it depends. I mean, I've said that QCAT's unlimited, so it might depend on what type of claim. So again, you've got to think about not just the dollar value, but you've got to think about what is the nature of the claim and where's the best place to take that matter. Also, think about whether the Commonwealth law applies or the state laws apply. So why would that make a difference? So it may be, for example, that if you're pursuing a matter that relates to exclusively Commonwealth jurisdiction, say a bankruptcy matter, then it's not something that you would litigate in the magistrate's court. There is cross-vesting jurisdiction between the courts, and so the magistrate's court has power to invoke, and every day does invoke, Commonwealth laws, even though it's a state jurisdiction. So there is a cross-vesting jurisdiction, but sometimes it is appropriate to select one court over another. So you need to think about that, and for the purposes of the exam, think about maybe even a little flow chart. Think about what you would do in these different scenarios. The next one is, client says, I want to sue faulty refrigerator at $2,000. Where would you take that? Where would you go for that? Obviously, you'd brainstorm at the start and think about all the other different options, but if the client says, no, I want you to litigate this, where would you sue for that? Faulty fridge, $2,000.
I think that would be a tribunal matter rather than taking it to the magistrate's court.
I think so. I think you'd probably go to the tribunal, QCAT, in Queensland. What about a faulty motor vehicle with $30,000? Where would you go for that? Probably the magistrate's court. One thing you can consider, QCAT or magistrate, one thing you can consider is the possibility of abandoning the claim. Now, I mentioned in QCAT there's the two limits. You've got the minor civil disputes jurisdiction and you've got the other. In the minor civil disputes, there are a specific list of things that go to that tribunal. And so it's not possible to cherry pick, if you like. So if you have a claim that relates to a bond dispute, a residential bond dispute, even though it's QCAT, it's in the minor civil dispute jurisdiction of QCAT as opposed to the general jurisdiction of QCAT. So it's not a case of you get to tick which one you want to go to. It depends on the nature of the dispute. And when it comes to a faulty motor vehicle, that would be in the minor civil disputes jurisdiction. And then think about things like an anti-discrimination matter. So your client says, all right, well, I want to sue. I've been discriminated. Where do I sue? And I want you to claim $100,000 in damages because of the effects of the discrimination against me.
I'd say that'd go to the district court, wouldn't it?
Yeah. Industrial Relations Commission. Jazz says a district court. So, or even QCAT has jurisdiction in anti-discrimination as well. So I'll just mention that one specifically so that you can actually do some research and think to yourself, okay, if I'm a lawyer, I'm expected to know the law, and part of the law is to know where I should take this particular matter. So that topic is examinable, but that comes as no surprise. I'm not saying it's on the exam, but I'm just saying it's within the group of questions that could be on the exam. So what we've covered in the last 2 weeks is, if you like, the issue of you as a lawyer being confronted with a client who has a problem, and you need to consider the options that are available to that client. Don't necessarily immediately think in terms of the option of going to court or a tribunal. Think about a whole range of options, and one of those is perhaps mediation, which we've talked about. So I'm just going to now segue into mediation a bit. We haven't talked a lot about mediation, but I mean, we all know what it is. We know it's a big part of dispute resolution now. And many courts and tribunals actively require parties to attend mediation or something similar in order to resolve their dispute. Now, mediation, if you like, is probably in the middle of a whole range of different ADR options. At the top, we might have negotiation, which is kind of the least interventionist and least determinative of the options. And down the bottom, we have the most interventionist and the most determinative, which is arbitration, which is really very similar to a court ruling. So it's sort of a privatised court regime, if you like. So there's a whole range of different ADR options that we talk about, but mediation is kind of in the middle there. And mediation is the most common. And if you're going to understand ADR processes, I'd suggest that you look at mediation, conciliation, and arbitration. Just get a feel for those. So mediation in its pure form is where a mediator attempts to assist the parties in coming to a resolution of their own dispute. There's a whole range of techniques that we use. One of them is to have a meeting in the same room, preferably, and set some ground rules. Ask one party to provide an opening statement. During that 5 minutes or so, we ask the other side to remain silent, maybe make some notes. We then reciprocate the process, and from that, the next step is we try to identify some issues. That requires, from the mediator's perspective, a lot of active listening, in that you're writing notes but maintaining eye contact and sort of working the room a little bit as well. And from that, we have the issues, or the agenda items are determined. There might be 3 or 4 agenda items. And bear in mind that in a mediation session, the mediator is trying to encourage parties to think about their interest and not necessarily their position. An interest is what is really important to them, and probably the sort of things they should be thinking about in the dispute, rather than necessarily their position. So in a workplace matter, it may be that my position is I should be paid $5,000 because I've been discriminated. The real issue might be I really want some recognition at work because I'm doing some really good stuff here and nobody seems to notice or care. So that might be your issue, as opposed to your position is I want $5,000. So in a mediation session, you'll often see mediators try and move parties away from their position and think about their interests. Then we have a group session where there's a lot of discussion goes on. And usually in a mediation, we'll have some private sessions where the mediator will talk to one party privately, keep that conversation confidential, then talk to the other party in a similar confidential vein. So that's sort of the mediation model. Conciliation is pretty similar, but it has a bit more teeth. In a conciliation model, typically the conciliator has power to make orders or at a lower level to at least provide advice and provide some commentary in relation to the what if this went to court or went to tribunal, what do you think the outcome would be? In a conciliation, the conciliator offers that opinion, maybe offers some advice, and maybe even make some orders, make some directions orders. So that conciliation is like mediation, but we up the ante a little bit. And I know that's racing through that very quickly. I hope I haven't been too quick. I'll just go to gallery view for a sec. Are there any questions from what I've said? Did you follow what I was saying there? We're all good? Okay. All right. Well, I'll go back to speaker view. And in a mediation session, the mediator uses a lot of different techniques, using open questions. Now, an open question is the sort of question that we use in examination in chief in a trial, which is, at its very basic, broadest level, tell me what happened on that day. That's a very open question, where you're asking the recipient of the question to provide a response in their own words in very broad compass. A closed question is typically one where the answer is either yes or no. So, was it a red car? Yes, that's a closed question. You're not inviting the other party to elaborate. So, in a court context, when I, as a lawyer, call a witness, I will ask that witness open questions so that the witness gives a response in their own words. But my friend, or my learned friend as the case may be, in cross-examination will ask closed questions typically, yes, no, whatever. Okay, so in a mediation session, mediators will often use open questions. They'll try to maintain eye contact. They'll do a whole range of different things to try to resolve the issue. Judge Kingham, formerly the deputy of QCAT, said that you need to be light on your feet to be an effective mediator, which means that you're ready to move from one topic to another, look at different avenues of approach, think about different ways that you can resolve the issue. And in the mediation session, the idea is that you create a bit of a connection with the parties, and as Professor Ashman of QCAT said, a successful mediator should feel as though the parties have made a new best friend in that mediation process. That is the mediator. All right, so bear in mind that in the ADR, oftentimes the court or tribunal will require the parties to attend that session and undertake that process to the best of their abilities. And also it may be prescribed. So under the Family Law Act, in certain matters such as parenting, the parties are required to undertake some form of ADR process before they can initiate. They need a certificate otherwise. All right, so if there's no other questions, and I appreciate I'm moving quickly, what I might do is move on to the redrafting exercise. Okay, so for this exercise, what I'm going to do is share the screen, and what we're going to do is try and reduce down to 100 words what currently is, I don't know, about 400 words. And this is sort of the typical exam question that I write in this field. So I'm just preparing that now. Okay. Oh, a lot of blue lines. Please excuse that. What I might do is see if I can use it. I'll just share the screen now. You should hopefully see, oops, you should hopefully see the document. I just started to go into options before I shared the screen, and I'll just see if I can get rid of the I don't often turn this off, sorry. Yeah, all right, so just a way of getting rid of those blue lines. So I've got the first part, which is this bit here, is A, and I'm looking for volunteers here because what we're going to do is, so that's just part A. You see I'm just artificially creating this. That's part B, and here we have part C. So what if I do this? Sorry. If you select one of those three, and you can just select any one that you like, and we'll get you to start redrafting that. And as you're doing that, I'll just say a few words. And I'm referring now to a thing called Clear and Precise Writing Skills for Today's Lawyers by McDonald and Clark Dixon, 3rd edition. It's very good. Step 1, separate out the statements. So try and, I use the highlighting a bit. So try and find the key words and discard the nonsense. Second is maybe group the statements, then remove the superfluous language, and then try to shorten into a more palatable form. So can I just give you 5 minutes or so? Maybe, and you can group up if you like, you can talk to each other, you can discuss, but the idea is that someone will attack A, someone will attack B, someone will attack C, and in your own section, you've got to reduce it down to maybe 30 words or so. So I'm just going to leave the keyboard now and I'll come back in about 10 minutes. Okay?
So I'm just going to jump in here. I'm not sure if everyone else is doing the same sort of thing, but so we're basically redrafting each section. Is that right?
Yeah, that's what I'm doing. I have difficulty with these redrafting things, so I'm having a heart attack, but I'm trying my best.
Fair enough. So it's basically we got to change it from what's already up there down to something that's easier to understand and not about 300 words long.
Yeah, yeah.
Okay. I think I've pretty much figured out A then.
All right, are we just about ready to compare notes? Okay. Well, look, what did we come up with for part A? Someone like to walk me through this? You can unmute your microphone if you like. So the main point, of course, is to identify the key issues, the key words, and put it into some order. So let's see, who had a look at, Luke, you were having a look at A? Feel comfortable letting us know what you came up with there?
Yeah, sure. Basically, what I got out of it was every student enrolled at this university will be ethical at all times.
Okay, yes. I like it. It's very simple, really straightforward. And I had more words in mine. Did anyone else have any further thoughts on A? Okay. And I had something like, while enrolled at this tertiary education or establishment, every student is subject to a prescribed ethical standards imposed by the university. I think yours is better, Luke. Mine's really quite passive voice as well. So thank you for that. What about B? Who wants to volunteer for any thoughts on part B? How did you go with that, Emma? Or Jazz? Can't hear you there, Jazz. Your microphone's unmuted, but we're just not getting... Can anyone hear Jazz? Now it's on mute, no? No, not getting anything coming through, sorry. Jazz or Emma? Anyone else wish to add any comments?
Jazz has just posted a response into the chat box, John.
Oh, into the chat box. Okay. Mine hasn't come through yet. Oh, there it is. Sorry. Thank you, Jazz. And Emma's microphone's not working. So I think you're typing on it as well, Emma. So I'll just read Jazz's at the moment. Any student guilty of plagiarism or unethical behaviour may be subject to academic investigation. Statements can be sought from any person as a witness by the Vice-Chancellor or any persons appointed. Thank you. And you work together with Jazz. So thank you, Emma, on that one. Now, did anyone have that? So those responses are great. What did I put? Mine's a little bit all over the place, but the Vice-Chancellor may initiate disciplinary action against a student for failing to meet the ethical standards. The disciplinary committee will hear evidence relating to the matter. Now, that's actually flowed through into the third one, which is C. So did anyone have a look at C?
That was me. And
Yes.
I'm not very confident with what I've written because I struggle with rewriting tasks. But what I've got is that the Vice-Chancellor may appoint a disciplinary committee as required to hear evidence of a complaint. The evidence may or may not be submitted by the student, regardless of whether they've obtained legal advice. And if the committee recommends, I can't even read my own writing. Prosecution. There we go.
Is this you, Chris? Is this you, Chris, speaking?
No, it's Leanne.
Oh, sorry, Leanne. Okay. Thank you, Leanne.
Yeah. No, that's all right. Sorry, yeah. And if the committee recommends prosecution, then a notice of a meeting will be provided to the student in writing.
Okay. Excellent. Thank you very much. And I had something similar. Committee will investigate the matter comprehensively, hear the matter fairly, governed by principles of natural justice. Then the student has a right to seek legal advice. The student may appeal an adverse decision. So thank you very much for participating. And for those of you that have watched that recorded session, I hope that you actually went through that task as well. And thank you very much for joining us live and providing those commentary or those comments. All right, well, that's all that I intend to deal with tonight. Hopefully you can see me now. I think I've stopped that share. I will post some material on UCrew, and next week is purely a review week. So if you have any questions at all, just join us live. If you want to challenge me to a typing test, you can do that as well. My voice recognition is not very good at the moment. If there's any questions, we'll speak to you through UCrew, and all the best. We'll see you next week.